Dear students, subscribers and the viewers, welcome to the IAS Mentor. This would be our lecture number 77 in the series Indian Polity, and today we are going to study a very important topic, parliamentary privileges. Not only an important topic but also a very interesting topic. As we'll proceed, what we'll try to understand as to what are the constitutional provisions related to parliamentary privileges and what exactly is a parliamentary privilege, what is the view that has been taken by the courts with regard to the parliamentary privileges in our country, and of course there is a need to codify the parliamentary privileges. As of now, the parliamentary privileges are not codified by an ordinary law. So is there a need to codify a parliamentary privilege or not is again a very important topic for your mains examination. So therefore, as we will proceed, wherever there is a need for an explanation and analysis when it comes to the mains examination, we will do that also. And wherever it is required for us to know the factual information which may be useful for your prelims examination will also be covered. So that's the objective in the way that you are going to take up the entire series. So we'll move forward and we'll try to understand first of all, what does it mean by a parliamentary privilege? And what is the rationality to provide these parliamentary privileges to the members of the parliament and the members of the state legislature? Alright, so before that, what is the constitutional provision that deals with the parliamentary privileges? There are two important articles in the constitution which deals with parliamentary privileges. One is article 105 of the constitution and other is article 194 of the constitution. While article 105 of the constitution deals with parliamentary privileges when it comes to the members of the parliament, whereas article 194 of the constitution deals with parliamentary privileges when it comes to members of the state legislature, MLA, and also the members of the legislative council. So for the state legislature, which includes both the MLA as well as MLC, which article provides the parliamentary privileges? Article 194. For the members of the parliament, be it a member of Lok Sabha or a member of Rajya Sabha, which article provides some the parliamentary privilege? It is article 105 in the constitution. So now let us try to explore and understand as to what is a parliamentary privilege. Before we understand as to what is a parliamentary privilege, what is the meaning of the word privilege? So privileges mean certain entitlements, which normally an individual may not be entitled, but certain group of people may be entitled to certain extra rights or immunities. So therefore, we consider those individuals are privileged. So similarly, when you ask me as to what is a parliamentary privilege, to put it in a very simple way, the members of the parliament under article 105 of the constitution and the members of the state legislature under article 194 of the constitution are provided certain extra rights and immunities which is not available to the other members in the society. You and me, as long as we become a member of parliament or a member of state legislature, we are not entitled to these privileges. So therefore, only the members of the parliament and the members of the state legislature, they are entitled to certain privileges. So therefore, those privileges are called as parliamentary privileges. So where those privileges are mentioned? As I already said, it is mentioned in article 105 and article 194 of the constitution. So why these privileges are conferred upon them? Let us try to understand what are those privileges that is conferred, but why these privileges are conferred upon them. For example, one of the privilege, I am not discussing all the privilege, one of the privilege of the members of the parliament is the right to freedom of speech in the houses of the parliament. A member of parliament inside the house can have the right to freedom of speech. So what does it mean he will have the right to freedom of speech? That means whatever he has spoken in the houses of the parliament, he is not liable to be prosecuted in a court of law. He is not liable to be punished for whatever he has spoken in the houses of the parliament. But however, this right to freedom of speech within the houses of the parliament, both for an MP as well as the members of the state legislature, this is not an absolute right. They are all subject to certain restrictions which we will try to understand. So therefore, the key point that you have to keep in your mind is the parliamentary privileges are not absolute in character. They are subject to the rules of the house and they are also subject to the other provisions in the constitution. So therefore, it is only qualified in nature. It is not absolute in nature. But however, subject to those restrictions, the members of the parliament and the members of the state legislature can exercise these privileges. So therefore, what is the rationality of giving this right to freedom of speech to the members of the parliament and the members of the state legislature is by using their right of freedom of speech in the houses of the parliament, they can make the government accountable. They can question the government. They can criticize the government. And that's why they are called as people's representatives. In fact, in a democracy, why people elect the representatives, it is not only that they'll form the government, but the people who are in the opposition parties or the other MPs in general, they have to question the government on behalf of the people. So therefore, the government is kept on their toes. Therefore, the government is made accountable. And that is one of the reason to empower the members of the state legislature and the members of the parliament to question the government. This right to freedom of speech is given as a parliamentary privilege. But this is not the only privilege. So therefore, what is the rationality of providing these privileges is that to empower the members of the legislature so that they can make the executives accountable, and making the executives accountable to the legislature is a very essence of a parliamentary democracy. And to perform this function effectively, the parliamentary privileges will help the members of the parliament and the members of state legislature. So this is the rationality as to why the privileges are given upon them. Now coming to the question of where the privileges are conferred. So what is the provision in the constitution? As I already said, it is article 105 and article 194 of the constitution which confers these privileges. But it is not only these provisions which confer the privileges under article 105 and article 194. The members of the parliament also get their privileges by what is called as, apart from the constitutional provisions, they also get their privileges based on what is called as conventional practices. So what is the source of parliamentary privilege? Both whatever is there in the constitution and also conventional practices. So therefore, if a question comes, the only source of parliamentary privileges to the members of the parliament is only from the constitution, to say that it is not the right thing. So apart from the constitutional provisions, the parliamentary conventions does provide parliamentary privileges. So how the conventional practices also provide the parliamentary privileges, for which what is written in article 105 and article 194 has to be understood first. So first what we will do is, we will go to article 105 and article 194 and try to understand as to what is given in these articles. So if we take a look at what is given in article 105, article 105 of the constitution says that the members of the parliament shall exercise all these privileges. One, it is saying right to freedom of speech. Right to speech within the houses of the parliament. And as a member of parliament, they will also have the right to vote. So it also includes right to freedom of speech and to vote in the houses of the parliament. So it is categorically saying that no member of parliament under article 105 and no member of state legislature under article 194 of the constitution shall be liable to be punished or liable to be prosecuted in a court of law for whatever they have said and whatever the vote that they have given in the houses of the parliament and state legislature. So therefore, they will have what is called as right to freedom of speech. That means, in other words, no member of parliament can be questioned in a court of law or punished by the court just because he has criticized the minister, just because he has criticized the government. That is not possible. However, it does not mean that this right is an absolute right. This right to freedom of speech is subject to what is called as the rules of the house. When I say rules of the house, the rules of the house mandate that every member of parliament use a parliamentary language, a constitutional language. That means they cannot abuse the other members of parliament, or they cannot abuse the ministers or the government. So that would be considered to be unparliamentary. So as per the rules of the house, they have to follow certain protocols when they question or when they criticize. And as per the rules of the house, they can talk only with the permission of the presiding officer. So therefore, even they have the right to freedom of speech, it is not that randomly they can raise a question, randomly they can criticize the government. First, they have to seek a notice, they have to seek the permission of the presiding officer, then the time will be allotted, and in the given time they can talk and they can express their opinion. So therefore, this right to freedom of speech is subject to what? It is subject to the rules of the house, and it is also subject to the other provisions of the constitution. When I say that the right to freedom of speech is subject to other provisions of the constitution, which means just because they have the right to freedom of speech, they cannot criticize the judges in a when they speak in the parliament or in the state legislature, because right to freedom of speech as a privilege to the members of the parliament or the members of the state legislature does not extend to what is called as the contempt of the court. So one restriction probably upon the right to freedom of speech to the members of the parliament and the members of the state legislature is it is subject to the rules of the house. The second restriction, it is also subject to other provisions of the constitution, where the other provisions in the constitution says that nobody shall engage in what is called as a contempt of the court. So therefore, the members of the parliament shall also not engage in what is called as contempt of court. They shall not criticize the judges. While they are free to criticize the government, but not criticism of the judges is part of their right to freedom of speech in the house, which is part of their privilege. So we'll have to understand first privilege that they exercises, right to freedom of speech and to exercise their vote, for which they are not liable to be punished in a court of law, and there shall be no proceedings against them, provided it is subject to the rules of the house and what is called as the other provisions in the constitution. The second privilege that they exercise is what is called as right to publish. What do you mean by right to publish? So this right to publish also includes what is called as right to expunge the contents. So let us try to understand first what does it mean by right to publish. Right to publish means that there are a lot of things that is discussed in the houses of the parliament and also in the state legislature. These are all called as parliamentary proceedings. A member can ask question, the member can move a motion, the member can introduce a bill, and subsequently there can be discussion on all those things. These are all basically what is called as parliamentary proceedings, and during the parliamentary proceedings a lot of things are spoken by the MPs as well as the MLAs in the state legislature. Now all these things are also recorded, but all these things will not be recorded and maintained for the official purpose. While if you are watching live telecast, we can watch all the things. Will all those things discussed in the parliament will be part of the official records for the future generation? No. Certain amount of content may be expunged by the presiding officer. So the presiding officer in case of Lok Sabha is a speaker, in case of Rajya Sabha it is a chairman. So they have the authority to decide which part of the portion shall be part of the official records and which part of the portion shall not be part of the official records. So if the speaker decides something what has been spoken in the houses of the parliament is inappropriate, although they can do that as per the right to freedom of speech and expression, they can engage in criticism of the government because they have the right to freedom of speech, but it may not be true in nature. So therefore the presiding officer can decide that these content shall be expunged from being part of the official records, and that's also part of what is called as the parliamentary privilege. So therefore removing certain content from being part of the official records is what is called as expunging the content. And the right to publish means, so whatever is allowed as per the authority of the house. So something is allowed to be part of the official records, and the house has no problem in somebody publishing all those things so that the people outside the country can also know about it. If the media people wanted to publish all these proceedings, they are free to do that, provided it is not expunged. So whatever is expunged should not be published. So this is again the privilege of the parliament to decide what shall be published, what shall not be published. So this is again part of what is called as their parliamentary privileges. So these two privileges are explicitly given in the constitution. So what are the two privileges that is explicitly given in the constitution? One is what is called as the right to freedom of speech, and the second is what is called as the right to publish and also the right to expunge the contents during the parliamentary proceedings. And apart from that, if you look into the constitution makes it very clear. Apart from these two privileges, which is directly mentioned in the constitution, in case of members of parliament under article 105 and in case of members of state legislature under article 194 of the constitution, if they want to exercise any of the other privileges, they are free to exercise, provided that the parliament makes a law in this particular regard for the members of the parliament, and the state legislature makes an ordinary law in this regard for the members of the state legislature. So therefore, what is the key understanding you should have? These two privileges are anyways given in the constitution. Apart from these two privileges, if any other additional privileges is to be conferred upon the members of the parliament, who shall provide that? The parliament can make a law, and by that law the parliament can provide those privileges. For the members of the state legislature, who can make a law? The respective state legislature can make a law and they can provide the privileges. But however, what you'll have to keep in your mind is, till the time the parliament is making a law or till the time the state legislature is making a law, so the members of the parliament and the members of the state legislature would continue to exercise these privileges, and in addition to that they can also exercise the privileges as a part of what was exercised by the members of the Constituent Assembly before the commencement of the constitution. So before the commencement of the constitution, if you see, the members of the Constituent Assembly were exercising certain parliamentary privileges. At that time we did not have a constitution, so therefore they were exercising parliamentary privileges on the basis of what is called as parliamentary conventions or conventional practices, which they have borrowed from the British parliamentary system. So therefore, if you sum up all those things, let me just write it, parliamentary convention. So therefore, if you sum up all those things presently, what are the privileges that is exercised by the members of the parliament, or what are the sources of this parliamentary privileges? If you see the sources of this parliamentary privileges, it includes those that is mentioned in the constitution and those which are practiced as parliamentary conventions. So for example, today there is one privilege that is given to the members of the parliament, that 40 days before a session and 40 days after the prorogation of a session. 40 days before summoning of a session and 40 days before after the prorogation of the session, the members of the parliament cannot be summoned by the courts. So therefore, however, this privilege is only in civil cases. But why this privilege is given? Because the members of the parliament has to prepare themselves for the session. So they have to prepare a bill, they have to prepare for the discussions as a people representatives. So therefore, they cannot waste the time in the other areas. So this privilege is given. But this privilege which is exercised and enjoyed by them is not directly mentioned in the constitution. Because of what reason they are exercising these privileges? Because these privileges continue to be a conventional practice which was exercised by the members of the Constituent Assembly before the commencement of the constitution. So now, if you have to understand as to what are the parliamentary privileges, first privilege is the right to freedom of speech and vote, although it is not an absolute right. The second privilege is right to publication and the right to expunge the content of the proceedings in the parliament. While these two privileges are directly mentioned in the constitution, apart from that, the constitution is saying the parliament or the state legislature, they can make a law and they can add more privileges to the members of the parliament. But however, no such law has been made till this point of time. So therefore, the constitution is also saying till the time such a privilege is conferred upon the members of the parliament and the members of the state legislature by a law made by the parliament or the state legislature, the members of the parliament and the members of the state legislature can continue to exercise such privileges as it existed before the commencement of the constitution. So before the commencement of the constitution, certain privileges were exercised by the members of the Constituent Assembly in the form of parliamentary, in the form of conventional practices. So that's the reason, because the law has not been made by the parliament or by the state legislature, today the privilege that is exercised by the members of the parliament or the members of the state legislature comes from two sources. Now what are the sources based on which they have the privileges? The first source is based on what is called as the constitution. The second source is what is a parliamentary convention. So this is basically the understanding you should have with regard to what is a parliamentary privilege, what are the sources of parliamentary privileges. Very, very important. So till this point of time, the laws has not been made. The laws has not codified the privileges. So therefore, they continue to exercise some privileges as a part of parliamentary convention. Now, if this is clear, now this is one of the area which has become really complex. And therefore, the exercise of parliamentary privileges by the members of parliament and the members of state legislature has been sometimes subject to the review by the courts, judicial review by the courts. So therefore, let us also try to understand what has happened, and what if the parliamentary privileges given in the constitution comes in conflict with the fundamental rights. And is it possible that the parliamentary privileges given in the constitution, can it come in conflict with the fundamental rights? Yes, in the history, if you look back, there were instances where the exercise of parliamentary privileges by the legislature, they have come in conflict with the exercise of fundamental right by the ordinary citizens. Under such a situation, what is the view that has been taken by the courts is what we are going to understand now. So let us take two important cases in the history of India. One is the MSM Sharma case, and the other is what is called as a Keshav Singh case. So if you look into the MSM Sharma case, what is this case is all about? MSM Sharma, which is also popularly what is called as the Searchlight case. Now MSM Sharma was an editor of a magazine, Searchlight. So what he has done is, he has published certain proceedings in the Bihar Legislative Assembly. So in the Bihar Legislative Assembly, there were certain things that was discussed as a part of their legislative proceedings. And MSM Sharma, because he was an editor of a particular magazine, that is Searchlight, so he got access to the content of these proceedings and he published all those things. But the problem is, he has published all those things despite the Bihar Legislative Assembly has passed an order not to publish those things. And it is the parliamentary privilege of the Bihar Legislative Assembly to decide what to be published, what not to be published. But however, despite a prohibitory order, Keshav Singh has published certain content. So therefore, the Bihar Legislative Assembly came to a conclusion that by doing this, MSM Sharma has breached the parliamentary privilege. It is our privilege to decide what shall be published and what shall not be published. And despite we send an order not to publish, you have published it. So therefore, you have breached our privilege. And because of the breach of privilege, we will also have the power to punish you. So they have sent someone to Keshav Singh, someone to MSM Sharma to know the reason as to why he has done that. Now, in the process, what MSM Sharma has done is he has approached the court. When this summon was sent to him by the Bihar Legislative Assembly, he has approached the court and he said the Bihar Legislative Assembly cannot summon him and they will not have the power to punish him because what MSM Sharma has done is MSM Sharma has merely exercised his right to freedom of speech and expression under Article 19, Clause 1, Subclause A. I am sure that you understand as to what is Article 19, Clause 1, Subclause A. Article 19, Clause 1, Subclause A allows for what is called as the right to freedom of speech and expression. It is basically the right to freedom of speech and expression. So that is what you will have to understand under Article 19, Clause 1, Subclause A, which is basically allows an individual to express his ideas, viewpoints in whichever way he wants to express. So that's basically what is Article 19, Clause 1, Subclause A. So MSM Sharma is claiming that he has expressed what is his right to freedom of speech and expression, nothing more than that. But however, the Bihar Legislative Assembly is saying that by MSM Sharma publishing this, he has breached what is called as his parliamentary privileges. So therefore, now the court has to decide as to what will have precedence if there is a clash between what is called as the breach of parliamentary privileges or the fundamental rights of an individual. So which will have precedence, which will be given the priority. The Supreme Court in this particular case has taken a view that the fundamental rights given in the Constitution, including the right to freedom of speech and expression, is subject to parliamentary privileges. That means in the name of right to freedom of speech and expression or any of the other fundamental right, you cannot breach the parliamentary privileges. And if you breach the parliamentary privilege, appropriate action can be taken by the legislature. So therefore, we will not be able to provide any remedy to the MSM Sharma in this particular case. So this is what is a view that has been taken by the Supreme Court in the MSM Sharma case. So who was given the precedence, or who was given more priority, or which was given more priority or importance? The parliamentary privileges were given the more priority. Now then came an interesting case, what is called as the Keshav Singh case. Unlike the MSM Sharma case, which was a direct case that was filed in the Supreme Court, Keshav Singh case was a case which was referred to the Supreme Court by the President under Article 143 of the Constitution. So don't worry about this Article 143. I'll deal with this in detail when I take up what is called as the powers of the judiciary. So in fact, one of the powers of the Supreme Court in India is that they can take up matters from the President, or the President is allowed to refer certain matters where there is a need for interpretation of the Constitution under the advisory jurisdiction of the Supreme Court. Okay, so this is a brief idea I should have right now for time being. Don't worry about it much. But when I proceed further, I'll let you understand as to what this is all about. Now, what happened in 1964 in Keshav Singh case? Keshav Singh was a Socialist Party worker. He believed in socialist ideology, so therefore he was very critical of the Congress government, I think, at that point of time in Uttar Pradesh, and he criticized the members of the Legislative Assembly of Uttar Pradesh. So when he criticized the members of the Legislative Assembly of Uttar Pradesh, he was sent a summon by the Uttar Pradesh Legislative Assembly, but Keshav Singh denied the first summon, so therefore a second summon was sent, and then subsequently he went there. But even after he went to the Legislative Assembly of Uttar Pradesh, his conduct was not very appropriate in the opinion of the Legislative Assembly of Uttar Pradesh, and therefore they have passed an order punishing Keshav Singh by imprisoning for 7 days. So 7 days imprisonment order was passed by the Uttar Pradesh Legislative Assembly because in their opinion the conduct of Keshav Singh has breached the parliamentary privileges of Uttar Pradesh Legislative Assembly. And as a part of their privilege, if somebody is breaching the parliamentary privilege, so therefore they can also be given the punishment. So when this order was passed by the Uttar Pradesh Legislative Assembly, now Keshav Singh has approached the court through his lawyer. He went to the High Court of Uttar Pradesh at that point of time, the Allahabad High Court at that point of time, and he took a stay on this order that was passed by the Uttar Pradesh Legislative Assembly. And then subsequently the stay order was produced in front of what is called as the Uttar Pradesh Legislative Assembly, and the Uttar Pradesh Legislative Assembly becomes so anxious that it has never ever happened in the history of India that once this order was produced in front of the Uttar Pradesh Legislative Assembly, think what has happened. The Uttar Pradesh Legislative Assembly passed again another order by saying that the two judges, because the matter was stayed and bail was granted to Keshav Singh in this particular matter by two judges in the Uttar Pradesh High Court. So therefore, when this order was produced in front of the Uttar Pradesh Legislative Assembly, the Uttar Pradesh Legislative Assembly for the first time in the history of India summoned both the judges of the Allahabad High Court, because the judges by passing an order to stay the order issued by the by the Uttar Pradesh Legislative Assembly, the assembly came to a conclusion the judges have also breached the parliamentary privileges. So therefore, they are also liable to be punished, and before punishing them, they wanted to summon the judges to seek their explanation. So it has never ever happened in the history of India that a legislative assembly summoning the judges for doing their work. And when this order was produced in front of the two judges really became anxious. So they took this matter in front of the Chief Justice of the Allahabad High Court. When this matter was taken in front of the Chief Justice of Allahabad High Court, the Chief Justice of Allahabad High Court summoned the entire strength of the Allahabad High Court. I think around 28 judges were there at that point of time. All the judges were summoned, and this matter was put in front of the largest bench that was there at that point of time. And the entire judges of the Allahabad High Court, headed by the Chief Justice of India, they took up this particular matter and they stayed the order that is passed by the Uttar Pradesh Legislative Assembly. This means, if now the Uttar Pradesh Legislative Assembly is to summon the judges, they have to summon all the judges of Allahabad High Court, including the Chief Justice of Allahabad High Court. So the matter becomes so serious that two organs of the state were about to lock their horns. And that is when the president interfered in this particular matter. The president exercises power under Article 143 of the Constitution, and he said, please both the parties wait, that both organs wait. I will refer this matter to the Supreme Court of India and seek a constitutional clarity in this particular regard. Under such a circumstance, the president intervened and he referred the matter to the Supreme Court of India to seek the opinion of Supreme Court of India under Article 143, where the Supreme Court opined in this particular matter that whenever there is a conflict between the fundamental rights and the parliamentary privileges, which will prevail is the fundamental rights, especially when it amounts to violation of the right to life and liberty of an individual. When you are going to punish an individual, then you are going to deprive the right to life and liberty of an individual. So therefore, the first and foremost thing the Supreme Court said that the parliamentary privileges are subject to what? They are subject to the fundamental rights. So in the previous case, what was given the precedence? In the MSM Sharma case, the parliamentary privileges were given precedence. But whereas in the Keshav Singh case, the fundamental rights were given precedence, especially when it comes to the right to life and liberty of an individual. So therefore, if you are trying to take away the right to life and liberty of an individual, the courts will have the power to judicially review, because it is going to affect the fundamental right of an individual. So two things importantly came out is what was given precedence is the fundamental rights were given precedence over the parliamentary privileges, and at the same time the Supreme Court said that the exercise of parliamentary privileges by the legislature is subject to judicial review. The second important thing that the Supreme Court held in this particular case, if the judges are taking up the matter related to the breach of parliamentary privileges, the judges are not liable to be punished, or the judges should not be considered that they have breached the parliamentary privileges. So therefore, the legislature cannot pass any order against the judges, and the judiciary will be able to judicially review these actions, and the fundamental rights will be given precedence over the parliamentary privileges, especially when it affects the right to life and liberty of an individual. So this is the basic understanding and how there is an evolution of the use of parliamentary privileges and vis-a-vis the fundamental rights exercised by the citizens can be understood from both the cases, that is MSM Sharma case and the Keshav Singh case. Very, very important cases in the history of India. Now, before I conclude this particular discussion, this is a topic that is related to the mains examination. So do you think that is there a need to codify the parliamentary privilege? Because if you look into Article 105 and Article 194 of the Constitution, if you look into Article 105 and Article 194 of the Constitution, it makes it very clear under this article that what are the sources of parliamentary privileges? One is it is to be mentioned in the Constitution, whatever is given in the Constitution. And apart from whatever is given in the Constitution, you should also understand that the Parliament or the state legislature has a power to codify these privileges. Yes, they can also codify. But till this point of time, neither the Parliament nor the state legislature has taken any step in this particular regard. They have not taken any step to codify the parliamentary privileges. So now the question is there a need to codify the parliamentary privileges? Do you think that the parliamentary privileges has to be codified? There are both the types of arguments. People who are in favor of codifying the parliamentary privileges, they said, if the parliamentary privileges are codified, then that would prevent the arbitrary exercise of power by the legislature. But today the privileges are not codified. So therefore, what is a punishment in every case is not codified anywhere. So therefore, it is at the whims and fancies or at the discretion of the legislature. So therefore, it is better that we codify the parliamentary privileges. We say what are the privileges, what can be seen as a violation, what can be seen as a breach, what shall be the punishment for such breaches. So therefore, the misuse of the parliamentary privileges in the hands of the parliament is very, very less. But if you do not codify that, then it can be misused. And if you do not codify that, it will also lead to what is called as parliamentary sovereignty. That means the parliament would become sovereign to decide where they can do it and when to do it, how much punishment to do it. But the constitution is not based on the idea of what is called as parliamentary sovereignty, but it is based on the idea of what is called as constitutional supremacy. Or in other words, when I use the word sovereign, that means that authority is a supreme authority. But however, our constitutional principles is not based on the idea of sovereignty of any particular organ in our state, but rather it is based on the principle of what is called as constitutional supremacy. It is a constitution that is supreme in our country. So therefore, everything in our country has to happen by way of constitution, and it should not lead to what is called as parliamentary sovereignty. And if the constitutional supremacy is to be established, and we need to have what is called as a codified parliamentary privileges. But on the contrary, people who are not in favor of this codifying the parliamentary privileges, they are of the opinion once you start codifying the privileges, then it becomes extremely difficult to amend these things in the future. Because people might find a new way to engage in breach of parliamentary privileges. So once it is codified, then you cannot punish an individual if that is not covered within the breach of parliamentary privilege. And every time the judiciary will interfere, so it will take a long time before punishing the individuals. So therefore, the effective deterrent may not be there for punishing people who are engaging in what is called as a breach of parliamentary privileges. So therefore, there are arguments on both the side. So it is for an individual student to arrive at a conclusion as to whether there is a need for parliamentary privileges to be codified or not to be codified. But however, if you ask me, codifying the parliamentary privileges in the longer run would be a better idea, because we cannot allow for any authority to exercise their power arbitrarily, or the scope of discretion has to be reduced. So therefore, we ensure what is called as the rule of law. So with that, we are coming to the end of this particular lecture. In fact, there was a commission, the National Commission to Review the Working of the Constitution, which is also called as a Venkatachalaya Commission, which was appointed in the year 2002. It was in favor of codifying what is called as the parliamentary privileges. In fact, M. Venkatachalaya was a retired Chief Justice of India. So he favored the codifying the parliamentary privileges. Therefore, if your opinion is codifying the parliamentary privileges, you can quote such reports and you can conclude your answers in that particular way. All right. So with that, you come to the questions, and with the questions, we'll wind up the session. Consider the following statements. The constitution is the only source of parliamentary privileges for the members of the parliament. Is the constitution the only source, or is there any other sources of parliamentary privilege? 2. The parliamentary privileges are presently codified by an ordinary law. Is the parliamentary privileges codified by an ordinary law? Presently. So that's the next statement. Third statement, parliamentary privileges are absolute in character. Do you think that the parliamentary privileges are absolute, or it is subject to the rules and the other provisions in the constitution? So if you have listened to the lecture, it is quite easy for you to answer the question. How many of the statements given above are incorrect? 1 only, 2 only, 3 only, none of the above. So you can pick your answers and you can put your answers in the comment box. So with that, we are coming to the end of the next lecture. This particular lecture, that is a parliamentary privilege. In the next lecture, I will start another important topic which is related to the parliamentary procedure, where we will discuss about the type of questions that can be asked. We will also discuss about the motions that can be introduced in the houses of the parliament, different types of motions. So all those things will be discussed in the next class. Again, a very important topic. If you have any questions related to UPSC preparation or any questions related to this particular topic, you can reach out to me. You can think me as your friend or a mentor or someone who can guide you in the right direction to clear this examination. You can always reach out to me. And if you like this video, please share it with your friends and family members. And it is going to be extremely useful for the students preparing for the UPSC IAS examination and other competitive examination. Thank you very much for watching this particular lecture. All the very best.